Members, my name is Jeremy Newman, Vice President of Family Freedom Project. Thank you for your time looking at this bill today. The Family Freedom Project does a lot of litigation on parental rights issues and obviously legislative work on parental rights issues. We've worked with Chairman Frank and with Chairman Hughes to draft this during the interim, and with kind of a panel of different legislative experts, judges, district judges. There's a letter being passed around from Justice Guzman, who was really involved in drafting this as well. And similar to what Chairman Frank said, the intent behind the bill is to place into the Texas Constitution rights parents already have, nothing more and nothing less. And we have 100+ years of constitutional case law that outline the rights that parents have. The issues that we are currently dealing with that we're hoping this will help solve are kind of twofold. The first one is that right now that case law is spread through over 100 years, and most of the time, in our experience, the attorneys that families can afford when these types of rights are in jeopardy are not the people who specialize in this area. Those people are expensive. And so you very often end up in situations where both the attorney and even often the judges who are dealing with these cases aren't familiar with the constitutional scope of the right that they're handling. And unless the parents can afford to get to the appellate courts, they often can't vindicate those rights. And so from that perspective, our hope is that it brings some clarity, and you don't have to have someone who's well-versed on the really voluminous case law to be able to vindicate a right that's so clearly stated in the Constitution. The second piece of it is to help ensure the longevity of that right, because right now it's in case law, and everybody knows case law is kind of fragile, right? And you can have new judicial appointments 20, 30 years from now with a different culture and different judges who have different views on the law, and those rights can evolve and change and even go away over time. And so what this bill does is it ensures that the rights parents have as they currently exist in case law are retained for future generations, and it kind of puts a bulwark against the threat that those rights would eventually possibly degrade or even go away completely over time. And Representative Dyson, as to the question that you asked, our perspective is no, that there aren't any laws on the books that are just blatantly unconstitutional that this would change. The expectation is that this would probably almost always be raised in an applied challenge, which is where the law itself is not facially unconstitutional, and the judges actually have to presume the law is constitutional. And an example of that is there was a case at the Texas Supreme Court in December, I believe, where there was a CPS case, and Justice Blackhawk actually mentioned this in his address this year. The O grounds is a way that CPS is allowed to terminate parental rights based on failure to complete services, and it doesn't necessarily have to be tied to a threat of harm to the child, just failure to complete services. And what the court found in that case was not that the law was facially unconstitutional, but that as applied in that case, it would be unconstitutional unless they read it to be really narrow, because basically their opinion was, we can't read this in a way that would allow the state to interfere in the parent-child relationship and sever that relationship if there's not any threat to the child. So we have to read it narrowly to avoid that. So that's the type of situation that it would maybe bring some clarity in, is we're not looking at situations by and large where we have whole statutes that are going to be struck down, because again, these are the same standards that everything's already subject to today. And it's really probably talking almost exclusively about applied challenges where we're making sure that as applied in a very particular case that we're not applying it unconstitutionally. So with that, I'm happy to answer any questions.